Hi, I'm Richard Murphy, and this is the 15th in the video series on the importance of tax transparency that I am hosting, and which is being made jointly by the University of Sheffield, where I work as a professor of accounting practice, the Global Initiative for Fiscal Transparency, and the International Budget Partnership. In this video, we continue to look at the importance of properly budgeting the tax revenues that a government seeks to raise, which is the process that began in videos 13 and 14. In this video, we look in particular at how the process of creating new tax laws should be managed as part of the budget process. At the heart of tax transparency is the idea that all processes surrounding taxation in a jurisdiction should be legal, transparent, subject to scrutiny, accountable. This is universally important, but especially so when it comes to the creation of new tax law. To ensure that the process of creating new tax law is transparent, it is essential that any proposed change to tax law should be published in advance of its enactment. Access to details of the proposed changes to the law should be free of charge and be readily available. The proposals should be explained as to their purpose and impact so that those likely to be affected are identified. The impact on those persons can be understood, the estimated revenue impact of the proposed change is clear, the proposed date when these changes should take place is made clear. In addition, a consultation process should take place on the proposed change or changes. This need not be protracted, but sufficient time must be provided for those seeking to offer opinion on the proposals to do so. To make this possible, it is also important that clear information is provided on the consultation process itself, and that feedback is provided to those who engage with it. This will include providing information on the proposals received and how they were considered in the eventual proposals put before a parliament. Only when a consultation is concluded should the matter be discussed in a legislature or parliament and be voted on to become law. Importantly, this consultation process should be made open to representatives of civil society. If there are difficulties in civil society participating because of a shortage of resources available to them, then a tax authority seeking to eliminate the bias that might otherwise arise in the findings of the consultation process should make grants available to those who might need them to enable them to make a submission. Care in selecting recipients of such grants will be important, with a particular bias being shown towards those groups in society whose interests might not otherwise be heard. These grants should also be tailored to encourage participation and might include directly covering expenses like transportation, childcare, food, and digital tools to ensure inclusiveness, providing a financial reward such as an honorarium, a cash prize, public service vouchers, or other material benefits in appreciation of the time spent in participation. Providing childcare services, support to vulnerable groups, such as disabled people or the elderly, through measures such as accessible premises and sign language interpretation. Recognizing civic participation as being a virtue. Efforts can be acknowledged through means such as diplomas, certificates, and ceremonies. Participation should be encouraged as part of a process to build a sense of belonging at the community level. Throughout this process of legislative reform, it is vital that timescales for implementation be made clear, and that the dates when changes in tax laws will take place are widely known. This will require careful communication, which is an issue addressed in more detail in Module 7 of this course. What we stress is that the process of tax transparency does not end when new legislation is enacted. As a matter of fact, based on our observation of tax law over long periods of time in many countries, tax law does not always deliver the outcomes that those enacting it expect. New tax law might, for example, undermine the effectiveness of other existing legislation, create new loopholes in tax laws that allow some to abuse the tax system, fail to raise anticipated revenues, deliver outcomes contrary to the well-being of some or most in a society, be simply unworkable, whatever the best intention of those proposing it were. In that case, in the interests of tax transparency, all tax legislation should be subject to a review process after it has been introduced. This is most especially true if the legislation introduces new incentives, allowances, reliefs, exemptions, reduced tax rates, or advantages for specific groups of taxpayers. It would always be wise to provide what are called sunset clauses when any of these changes are proposed. These clauses require that all such provisions automatically lapse after a period of time, necessarily requiring a review if they are to continue. We do, however, think that reviews are important in all cases, and that review date should be announced when a change is to be introduced. Only then can countries consider themselves to be truly tax transparent, which we think to be vital if tax morale within a jurisdiction is to be maintained.